why she gave us this, but
But if you want to do,
Luckily, it's a lot of money. These clerks have been here since 4 in the morning trying to figure this out.
they get here that early.
Yeah, they get here.
It's funny. Look, the TV is.
Shoot, look at this. I can't.
Oh.
Muscle memory.
you'd have to go to another one. That doesn't matter while there's on. When that blue light comes
Mic
on.
reset, great.
Okay.
Can we get some medical reset? Oh, no, sorry.
It don't fit.
We've got to wait for the blue man to come on. He's going to go turn it on now. Be just a minute.
It's not even on.
Yeah, if you're going to speak on the record, you need to be in front of the microphone, if you don't mind, please. Okay, good morning. We're on the record.
Morning, Your Honor.
We're addressing the case styled in the interest of JASS, AD, CC, and DC. I don't have a case number reflected here, but.
No, we got a case number after we filed the petition.
Gotcha.
We'll get that on Monday.
Okay. What is your name?
Paul Stevenson, Attorney General's office on behalf of the department. The mom is incarcerated, and we are, at this point, just seeking to reset the case till Monday so she can be transported.
Anyone else here have an interest in the case?
Intake and placement with child net.
Okay, all right, good morning. Anyone else? Okay. I couldn't hear, I'm sorry. Say it one more time? Okay, all right. So any objection to having the matter reset to Monday? Apparently the mom's incarcerated. Okay, so that's what we'll do. We'll enter an order and provide you a
an
copy.
order, Judge.
Thank you, sir. Appreciate it.
It just resets it to Monday, that's all it does.
Where did you get this? Oh. I was like, where did that come from?
All right, as I understand it, we can address the juvenile detention hearings. All right, the first case is Stuart Allen. Mr. Allen? Oh, he's walking. Okay,
Marlise Mercado with the Public Defender's Office for the record, Your Honor.
good morning.
Good morning, Judge Camille Smith on behalf of the state.
Good morning. Come on out here so I can see you. Are you Stuart? Stuart Allen? All right, good morning, Stuart. And who else is here for Mr. Allen? What's your name? Say it again? Deborah? Okay, what's your last name? Okay. All right, so Stuart's been charged with burglary of an unoccupied dwelling and possession of burglary tools with intent to use them. And the court's reviewed the probable cause affidavit. Is there anything?
No objection, Your Honor.
Okay. And I've reviewed it. I do find probable cause. And where does Stewart score? Let's see. Home detention.
And his next court date is July 28th at 8:45 before Judge Ross.
Okay. So Deborah, I'm sorry, I forgot your last name. Weston. Ms. Weston, so your son's going to be placed in home detention, so he's going to be sent home to you for you to supervise him and watch him. All right? You understand? He's got to come back for his next hearing date, which is August 4th.
July
I'm sorry. Where does it say it on? I see. It's not on the order. Okay, thank you. All right, so that's going to be the next hearing date, so make sure he gets there. Okay?
She could take him to court, is that what you're asking?
Well, my court date is Monday coming in Gainesville,
Right?
so I would like to know, can I?
Oh, you're asking if your daughter can keep an eye on your son while you're gone? Is that what you're asking? Ma'am, you know, you're his mother. You need to make sure that he's properly attended to, and as his mother, whatever you think is in his best interest to make sure that he's properly cared for and that he gets to his court hearing. So that's, you know, whatever you think is appropriate. Okay? All right. Okay, thank you. You need this. Thank you. All right, next is Deontavius Glinton. Good morning. Hi. Come on up. What's your name?
My name is Ebony
Ebony what?
Jones.
Ms. Jones? Sir?
James Parisi.
And you related to Mr. Glinton,
Yes, he's my son.
your son? Okay. You, sir?
Stepson.
Okay. All right. Mr. Glinton, where are you?
He actually just got arrested last night
Oh,
in Palm Beach.
in Palm Beach. So he's in Palm Beach.
Yes.
So he's going to have to be transferred over there. Okay. Right, he's still in Palm Beach, so I can't conduct a hearing, obviously. He's not here, so this is going to be rescheduled. Would we reschedule it to Monday, or?
Out, and then he picked up the new charge.
Yeah, last
So that's
night.
what happened. So that's why he's not here today. He was supposed to be brought in with them, but then obviously he got picked up last night. So I don't know if when Your Honor would like to reset this, but if he's held in Palm Beach for the 21 days, I don't know if we would have to have this set after.
Would they typically transfer him down here while he's being held, or would they wait until after the 21 days? Do you know?
I believe they wait until, depending on what the court finds over there, if he needs to be held for 21.
Okay, and that will hold him even if he's up there.
Send him here.
Yeah, he's failed to appear. We'll enter a pickup order. They're going to hold him there, but what's going to happen is when they're done with him or when they feel it's appropriate, they'll send him over here. And that way he won't be released in the interim. All right, I think that's appropriate.
Thank you, Your Honor.
Okay,
Can you just fill this out before you leave? Thank you.
thank you. All right, next is Azaria Roker.
President in custody, Your Honor. In the second chair, or
Okay.
second row,
All
first
right.
chair.
Good morning. Anyone here outside for him? Okay. I think Mr. Roker is picked up on a warrant, right? Let's see. Okay. That's what it says here. All right, Mr. Roker, you understand that? There's a pickup order. You got to go down to Dade, and they'll address your case down there. So they're going to hold you here until they transfer you. Thank you, Mr. Roker. Thank you. What is this? Luann Noel. The record should reflect that Ms. Noel is not present. We're going to check outside. Okay. Sign the order to take the child into custody. Thank you. Jacob Johnson. Mr.
Custody,
Johnson.
Your Honor.
Good morning.
First row.
Good morning. What's your name, ma'am?
Janice Carter.
A little louder?
Janice Carter.
Ms. Carter, thank you very much. So we're addressing Jacob's case. Apparently, there was an order to take Jacob into custody. I can't read the signature of the judge, but as a Broward County judge, apparently it's alleged that Jacob failed to appear for a status hearing in his case.
Sir.
Released home? Just straight out release? No, hold on. All right, just give me a moment. Ma'am, Jacob lives with you?
Sir.
Okay, Mr. Johnson, I'm going to release you at the request of the department. Apparently, you missed a hearing. If you miss another hearing, you understand that it may not happen. You may be detained. Okay?
So I can't come if I don't know.
You here July 18th? Okay, perfect. Thank you, Your Honor.
Thank you. Thank you. Good luck. Good luck, ma'am. Javon Sirenord.
Is present in custody, Your Honor, back row, first chair.
Good morning. Okay. All right, Mr. Sirenord, you've been charged with loitering or prowling and resisting or obstructing an officer without violence. And I've read the probable cause affidavit. Is there anything you wanted to mention with regard to that?
No objection, Your Honor.
The court finds probable cause. And Mr. Sirenord, he's scoring 0 points. You're recommending that he be released? Okay. So, Mr. Sirenord, you're going to be released from custody today. All right, you're going to be advised when your next hearing date. Make sure you show up for the next hearing.
Thank you, Your Honor.
July 19th at 1:30. You'll get in writing. Thank you. Dwayne Jackson. Good morning, Mr.
Present in
Jackson.
custody, Your Honor.
Okay, thank you.
Your Honor, I did speak with JPS in this case. He does qualify, and his aunt has agreed to allow him to participate in the program as well. So defense would be requesting that Your Honor would release him on home detention or out on the JPS program.
What's the JPS program?
Sorry.
Good morning.
Good morning, Your Honor. Real Juan Adigan, on behalf of Juvenile Predisposition Services of Broward County. It's a new initiative that was started, I want to say a little over a year ago.
Is it like pretrial release for juveniles?
Yes, Senator,
Okay.
yes.
All right.
So yeah, we try to implement services for the youth as well as the family, implementing therapeutic services, case management. And we've been working with a number of youth throughout the year. We've actually been seeing some improvements.
Good. Sounds great. Sounds like a great option. Good morning, ma'am. What's your name?
Good morning, Omarashi Butler.
Ms. Butler?
Yes, sir.
Okay. All right. All right. Is there any objection by the department? So, what else, counsel, what else, if anything, did you want to tell me with regard to the request to release him to the JPS program?
Just that he does score the 17 points. It is in your honor's discretion. He does qualify. His aunt is here. She's willing to help him participate in the program. I did speak with Dwayne. He is very much interested in entering the program and is willing to be active in it. And so thus we were requesting that your honor would allow him to enter the JPS program and release him.
Okay, ma'am, so does Dwayne live with you? Yes. Yeah? So the charge is grand theft of a motor vehicle, 3 counts. And I've read the probable cause affidavit and do find probable cause. So what would be the terms other than some sort of periodic reporting with regard to the release?
Well, again, he will be receiving case management. We will be implementing therapeutic services. He will be required to attend our group therapy sessions twice a week. And it's really just another form of some additional supervision to assist with the family.
Also, if your honor were not inclined to release him, we could request that he be released with the ankle monitor as well. I know that's another option. But we would be initially requesting no ankle monitor and to be released with JPS.
And Judge, if you're inclined to go against DJJ's recommendation of secure detention in lieu of the program, state would be requesting the ankle monitor.
Ankle monitor. All right, let me just take a look at the history. All right, I'm inclined to release Mr. Jackson to the program, but I think the ankle monitor is a good idea given the recent history. All these incidents, there, it looks like there were 2 in July of this year. If it's in the order that these are set, then I don't really need one. Then I don't need it, if it's in order. Oh, I haven't even seen those.
That's what, we were gonna print them, but it was too loud, so we're gonna do it. Hopefully.
Well, I
Did you
have that
mark which
first.
ones? Did you mark which ones are missing? Or is that what this means? And Judge, we have all the paperwork when you're ready. It's, we can't hold it up, but we're just gonna have to look through as we go. It's fine. It's gonna be patient.
It's outside, Tony, for any of those? That's it? Okay, Mr. Cohen?
If you don't have mine, I can give it to you to read it.
The problem is I don't, it may be here, but I don't know where.
May I?
Okay, I don't have the docket. What's the name?
It's Benjamin Smith, may I? It's fairly simple.
Is it a misdemeanor or a felony?
Benjamin Smith is a felony, and I think this lady found it at the end of her file.
Yeah, are we doing the adults or are we doing the juvenile? Is it adult? Or we
Adult.
have to get out of,
Benjamin
have to
Smith.
get record and the juvenile has to, can't be here.
I'm sorry?
Are we finished with the juveniles, Your Honor?
I think that's it for the juvenile.
So, if we wait a minute before we start, because it has to be on the record, so can we wait till juveniles kind of like get out of here before we,
You got it.
live stream for the adults?
Yeah, no
Not to
problem.
be rude, I'm sorry, but
It's okay.
the adults have to be on the record, but the juveniles has to be out of here.
Gotcha. Turn.
Thank you, Your Honor.
Benjamin Smith. All right.
Here he is.
Counsel, would you announce your appearance?
Good morning, Your Honor. If it please the court, Herbert Cohen on behalf of Benjamin Smith.
North Broad, Your Honor.
They're bringing him up, Mr. Cohen.
He,
Good morning, Mr. Smith. Your attorney's here in the courtroom with me.
Good morning, Mr. Hunt.
good morning, Benjamin. Judge, may I?
Yes, sir.
Thank you. Please, the court, if you look at the probable cause affidavit, I would submit that there are, if not most of the charges, not sufficient probable cause. Notice the date of the incident is July 4th,
I've read it. I've got concerns with the drug charges. Let me hear from the state.
and he wasn't in the house at the time. They arrested
I
him
got a
last
few
night at the
problems with
hospital.
the drug charges.
Yeah.
And Judge, I did review the probable cause affidavit. State would be asking for 48 hours to perfect.
Okay. What's your position with the dealing in stolen property count?
My understanding of that is, Your Honor, I showed the court deputy. I don't think the court needs to see. My client has a wound, a gash this far up and down his chest. They went to the hospital and arrested him. My position with that is, this was a firearm that was found in his house along with everything else after he was taken to the hospital. There were other people in the house. So there's a possession.
The issue is possession of control, right?
Exactly.
Okay.
Exactly.
All right. The court finds that there's no probable cause. I think this could potentially be cured by the state, and I'm going to give them an opportunity to perfect probable cause. Any objection to the 48 hours, sir?
It's appropriate, Judge. I mean, I like to object, but it is appropriate, and you're correct in your ruling. I would ask the court, based on what the bonds are, my client has been here 17 years legally. He has no prior criminal history, and I think a $5,000 bond is appropriate. With his gunshot wounds, he's really not going anywhere, but I would ask the judge to consider reducing the bonds on these in light of everything between $5,000 and no greater than $10,000 total.
And Judge, state would ask that you refrain from modifying the bond conditions until state has had an opportunity to perfect the probable cause affidavit.
Yeah, I think that's reasonable. So they'll be left at, I guess, what they used to call a convenience bond amount. I think these are appropriate, given what I've read, assuming the state has the ability to perfect, and this can be addressed within the 48-hour time frame. So respectfully, the court denies the motion to reduce these bonds. They'll be left as indicated.
Thank you, Judge. And in 48 hours, will he be back to magistrate court, or
Yeah, that's
Okay.
what it should be, be on Monday, I guess, right?
Monday AM?
Monday morning.
Okay.
Yes, sir.
See you then. Thank you,
nice
Judge.
weekend, Mr.
Appreciate
Cohen.
it.
Thank you, Mr. Hunt.
Thank you.
No PC on all 4 counts.
Remember,
ma'am.
I invoked your right to remain silent, and we'll talk.
Thank you, sir.
Thank you, Judge. Have a good weekend.
Thank you.
Okay. Do you know how it is that I could address, I mean, does this allow me to address everybody? You know? Nobody knows? Why don't you grab him real quick? Thank you. Thank you. Okay. All right, good morning, ladies and gentlemen. You're all here for our first appearance hearings. During these hearings, the court will establish whether there's probable cause for the arrest that was made. If the court finds probable cause, we'll address the issue of bond. If there's no probable cause, you'll either be released or the state will be given an opportunity to perfect the probable cause affidavit. We'll also address whether you have counsel or not, whether an attorney will be appointed for you, that is the Public Defender's Office, for purposes of the hearing today. And finally, if there is probable cause, we'll address the issue of bond to determine what, if any, pretrial releases terms would be established, including monetary bond or pretrial services. You all have the right to remain silent pursuant to the Fifth Amendment of the U.S. Constitution and provisions of the state constitution. You're not required to say anything about your case or answer any questions. If you say anything during these proceedings, what you say will be recorded and it may be used against you by the state. You have a right to communicate with your lawyer and with family and or friends, and arrangements would be made for that through the jail. All right, we'll begin with Tashara Silas.
Good morning, Your Honor. Ryan Dessler, Public Defender, on her behalf. She's President May.
Good morning. Good morning, ma'am. Ma'am, you've been charged with domestic violence battery. And I reviewed the probable cause affidavit and do find probable cause. And I'll hear from the state and from the defense with regard to the issue of bond.
Judge, state's recommending a $1,000 bond and no victim contact.
Okay, yes, sir.
Your Honor, Ms. Silas and the alleged victim, they live apart. The alleged victim was in Delray, or excuse me, the alleged victim was in Deerfield. Ms. Silas lives in Delray. Ms. Silas lives with her mother as well as her siblings. She worked at McDonald's as a crew manager. She makes about $400 every 2 weeks. She is finishing her high school degree this summer online. She is going to turn 19 in September, so she's currently 18 years old. I'm just not sure the $1,000 will be attainable by her to be able to bond out. I would ask for a lower monetary bond, maybe $500, Your Honor.
Okay. All right, the court sets bond at $500. And Ms. Silas, the condition of your release is that you have no contact with the victim.
Yes.
Thank you. All right, that means don't go to the victim's place of employment, their home, their school. Don't go near their car. Don't have any contact with them verbally or otherwise.
Yes, sir.
All right. Good luck to you, ma'am. Thank you. Thank you. Brianna Hutchinson.
President approaching.
Thank you. Good morning, Ms. Hutchinson. You've been charged as well with domestic violence battery. The court finds probable cause upon review of the affidavit. Okay, state?
Judge, state would be asking for a $500 bond and no victim contact.
Okay. Yes, sir.
No argument, Your Honor.
Okay. Bond is set at $500. Ma'am, you're not permitted any contact with the victim.
Understand?
Adalina Kodra.
Gonna be North Broward, Your Honor.
She's a medical reset.
Reset? Okay, thank you. Ike Addison.
President approaching. In May.
Thank you. Good morning. You're Mr. Addison? All right. Good morning, sir. You've been charged with domestic violence battery. And I've reviewed the probable cause affidavit and do find probable cause. And I'll hear from the state.
Judge, considering the alleged injuries, I would like to recommend a bond of $3,000. The defendant does not have any priors, but considering the incident and also no victim contact.
Your Honor, for Mr. Addison. I'm sorry.
Hold on one, sir. I'm sorry.
They can go ahead.
Okay, go ahead, sir. Yes, sir.
For Mr. Addison, Your Honor, he could stay away from the victim. He could stay with a friend/coworker for the time being. So keeping away from the victim and not having contact is not going to be a problem for Mr. Addison. He works as a mechanic. Depending on how much work he gets, his income fluctuates. I would ask Your Honor for a $1,000 bond for Mr. Addison.
All right. Was there something else you wanted to add? Okay. All right, thank you. The court imposes a $1,000 bond and a condition of no victim contact. Sir, no contact with the victim of any kind, sir. Jean Luxon Perdelis.
Present, Your Honor.
Thank you. Good morning, sir. Mr. Perdelis, you've been charged with domestic violence battery, felony battery. I've reviewed the probable cause affidavit and do find probable cause, sir.
Judge, they would be asking for a $3,000 bond in addition to pretrial release with a standard pretrial release and no victim contact.
Okay, defense?
No objection, Your Honor.
Okay, the court sets monetary bond at $3,000. The respondent will be monitored by pretrial services, standard pretrial release. And Mr. Perdelis, you're not permitted any contact with the victim. Trouble reading this one. I think the name is Tevis Robinson. Tevis Leonard Robinson.
President Maine, Your Honor.
All right, good morning, sir.
Good morning.
There is an out-of-state hold, apparently a felony warrant. Actually, it's out of county, Marion County Sheriff's Department. It is out of state in Tennessee. So, sir, you're going to be held and then sent out extradited to Tennessee. So you'll be held with no bond. Good luck, sir. Monica Joan Montpremier. Ms. Montpremier, M-O-M-P-R-I-M-I-E-R.
Bonded, Your Honor.
Oh, she bonded? Okay. Thank you. Thank you. Karen Schultz. Thank you. Good morning, ma'am.
Good morning, Your Honor.
What's your name?
My name's Karen Scholes.
Ms. Scholes, all right. Ma'am, you've been charged with DUI, first offense, driving under the influence, causing damage to property or to another person, and with a traffic infraction of failure to use due care.
Yes, sir.
And I have reviewed your probable cause affidavit. I do find probable cause as to the offenses charged.
Okay. Yeah, my lap. Can I add something, Your Honor?
Everything you say is being recorded. Whatever you say is going to be used against you by the state. It's up to you whether you want to talk, but
Yeah, I just wanted to let you know that I had 13 years sober, regularly attend AA meetings, and I had a relapse.
okay.
I have a sponsor and whatnot.
All right, I'm going to hear from the state and concerning the issue of
Judge-
trial release.
Yeah, I wasn't allowed a phone call.
One moment, ma'am.
I wasn't allowed a phone call.
Judge, her bond was posted.
It was posted?
Her bond was already posted.
Oh, it was posted?
Yes, Judge.
Oh, okay.
Oh,
All right, so ma'am, apparently someone's posted bond for you, so you'll be getting out.
okay. Thank you.
All right.
Have a good one.
Thank you. Shakira Gordon.
Her bond has been posted as well, Your Honor.
Okay. Thank you. Zakendra Gary.
North Broward Medical Reset.
Okay. Thank you. Rebecca Strobridge.
That's also North Broward, another medical reset.
Thank you.
You're welcome.
Gardino Charles.
She's President Maine, Your Honor. She's approaching.
Thank you. Good morning, ma'am. Ms. Charles, you've been charged with 2 counts of child abuse without resulting in great bodily harm and probation violation. Let me check that. Okay. All right. Ms. Charles, by the way, a shelter hearing was conducted that was reset, or well, it was scheduled and reset to Monday. So you're going to have a shelter hearing with regard to the children on Monday, ma'am. Okay? Okay. So, hold on. Come on back, ma'am. So there's an outstanding probation warrant, is that it?
Yes, Judge, she was on probation for Bat Leo in front of Judge Yusan. That's on count 3. She's being held no bond on that. As to counts 1 and 2, state would be recommending a $5,000 bond as well as pretrial release if she's able to post bond, considering the allegations and her prior history.
All right.
Jardine.
Yes, sir. Yes, sir.
Your Honor, I would just ask for nominal bonds on count 1 and 2. She's going to be held no bond on the VOP until she sees her judge anyway. I would ask for $1,000 on count 1 and count 2. To me, she's going to be held anyway on no bond.
Okay, given all the circumstances, I think that's reasonable. So the court finds probable causes to counts 1 and 2, and monetary bond is set at $1,000 as to each. And if the defendant is released, she'll be released as well to pretrial services. Okay, July 19th is your next court date, ma'am.
And standard.
Standard pretrial, yes. I can say respondent, right? Yeah. Old habits are hard to break. Cynthia Briston. Thank you. Good morning, ma'am.
Good morning,
Is your last name Briston?
Kristen.
Briston, okay. That's hard for me to read. Ms. Briston, you've been charged with driving while your license is suspended, third or subsequent offense. And you have a traffic infraction for having improper or non-functioning taillights.
Yes, sir.
Cynthia Patrice Briston.
Yes, sir.
Right. I'm being asked by the Public Defender's Office to confirm which case it is. Do you have that one?
I only have one.
You had a chance to look at this one, right? This is Cynthia Patrice Briston is the name. I've got 2, a driving while license suspended and then a traffic infraction.
That
That's the one from yesterday.
You see it now? Okay. Okay, all right. Ma'am, raise your right hand to be sworn, please. Do you swear or affirm to tell the truth?
Yes, sir.
All right. Ma'am, the court finds probable cause as to the offenses charged. The Assistant Public Defender is going to ask you a few questions with regard to the issue of your ability to post bond or pretrial release, okay?
Yes, sir.
All right, go ahead, ma'am.
No, no, ma'am. No, I'm in the process of getting disability because I was in a bad accident. I have one son. He's 26. He helps out. Yes, try to. All my life, 56 years. Yes, ma'am. No.
State, you have any questions?
Oh, Judge, no questions.
Okay.
Based on her testimony, I was asking her to release her from recognizance. She doesn't have an ability to pay for the bond, whatever bond would be. It's suspended, the case is not filed in time, she's unemployed, she's on the process of paying disability.
And Judge, I defer to you.
Okay, I think that's reasonable. However, I will impose a condition that the respondent not drive an automobile. So, ma'am, I'm going to release you on your own recognizance, but you can't drive an automobile. I don't care whether you get your license back or not. Until this order changes by the court, you can't drive an automobile. You understand?
Yes, sir.
Okay.
Thank you.
Yes, ma'am. Good luck. All right. Yvette Arias.
Good morning, Your Honor. Ms. Arias is at the Paul Ryan School.
Paul Ryan, thank you.
Morning, Judge.
Good morning, ma'am. You've been charged with battery, a second or subsequent offense. And actually, the reason you're here is there was a capias issued, and it's a no bond capias. Yes, ma'am. It's in case number 177028, CF 10A, before the Honorable Ernest Calra. And you're to be held no bond pursuant to the judge's capias, and you'll appear before the judge at the next hearing set for you. Yes.
This is.
Yeah, oh, it is?
Yes, Judge.
Yeah.
All right, one moment. Let me review this. Oh, I see. Okay. So it's a no bond, but it says hold for magistrate hearing. So that it's two counts, felony battery with prior conviction.
Judge, do you have a probable cause affidavit?
You know, I don't.
Okay, if we could put this one on recall, I can print for the court and for.
All right, Ms. Arias, we're going to recall this. I don't have an affidavit to see what the underlying facts are or allegations are.
Yeah,
And I need to know that before I can establish what, if any, bond should be set. So I'm going to ask you to take a seat, and we'll call the case a little later. Thank you, ma'am.
Okay.
Sonia Kisro. Is that you, ma'am?
Yes.
How do you pronounce the last name?
Cicero.
Cicero.
Judge, we're in the same boat with Ms. Cicero. It's a change of charge. I'm going to pull up the documents for your honor and.
Okay, Ms. Cicero, again, this is a change of charge capias in case number 177573 CF10A before Judge Usan. And I need to get a copy of the probable cause affidavit so I could address the issue of release, okay? So have a seat and we'll recall your case. Clermenda Jean.
The state does not have a probable cause affidavit either, Judge.
Yeah, it's
Yeah, this is recent from yesterday.
Okay, let me see.
Clermenda Jean. Okay. Well, she's not appearing anywhere, so. By the-
Out on loan, Your Honor. Can we
Okay.
reset her?
Yeah, we'll reset this. By the way, there is an affidavit attached to the paperwork I have.
We don't have a copy.
You don't have a copy?
No.
Okay. Okay, thank you. All right, so Clemenda Jean will be reset. Apparently, she's not here. Do you have copies for that? Or- All right. Yvette Arias, recall. Where was she?
All right.
Okay. And Counsel, have you gotten did you get
Yes,
a copy of the PC? All right, I'm going to look at it too. Ma'am, we just got the probable cause affidavit. I'm going to take a moment to look at it, and then we'll address your case. All right, Counsel, you all set?
Yes, Judge.
All right, I'll hear from the state then.
State would, if Your Honor finds probable cause, state would be recommending a $5,000 bond as to count 1 and 2 with pretrial release, and level 2 pretrial release with a GPS monitor and no victim contact. Areas.
Arias.
And Judge, she does
Yvette
have
Arias.
priors if you'd like to hear.
Okay, ma'am, raise your right hand. Do you swear or affirm,
Yes, sir.
swear or affirm to tell the truth?
Yes, sir.
Okay, all right. The Assistant Public Defender is going to ask you a few questions, all right? You can put your hand down. Please answer her
Okay.
questions, and then the state may have a few questions. Go ahead.
Ms. Ayers, do you work?
Yes, I work.
How much money do you make a month?
If I work on commission, so 2,000.
Okay, are you able to post a $5,000 bond?
I can't hear you, ma'am.
Are you able to post a $5,000 bond?
A $500 bond?
5,000.
A $5,000 bond?
You would have to pay
I could probably do a $400 bond.
Do you have any children?
I do not have any children. I don't have any family in Florida, or I only have a brother and sister in New York that I haven't seen since 1990. But I have no family. I do have a good friend, but I don't have any family to post my bond. And so I could call a bondsman and make maybe payment arrangements, you know, and go from there. Because obviously I don't have a cell phone with phone numbers on it to like go call people.
Based on those circumstances, I would ask if you have maybe
I can do the pre-trial and go, the issue is that I have a dog, and my dog is at the, room that I was renting, and, my rent is paid until the end of the month, and, with the no contact with the victim, I would like to go with a police escort and get my dog.
Judge, based on circumstances, is Your Honor inclined to release her to pre-trial level 2 if you find necessary, just so she can at least be able to get the dog back?
I just want to save my dog.
Since she won't be able to post bond today, most likely.
And Judge, I will,
Well, I could,
One moment, ma'am. Hold on, state.
Judge, I will tell you that she has a 2002 aggravated assault. She has 2 prior misdemeanor batteries, a prior felony battery, a prior arrest for battery on a law enforcement officer, conviction on the resisting without violence, the lesser. And so she does have violent priors, and based on that, that's why the state is asking for that bond with pretrial release.
okay.
For an ankle monitor, she will be supervised, she won't be able to have any victim contact, so she'll be able to at least get the dog back.
Okay.
Okay, all right, thank you. All right, the court finds probable cause. Well, I'm going to set a bond, a monetary bond on each count at $1,000. And, ma'am, you'll be ordered to pretrial release,
Yes, sir.
all right, with an ankle monitor. So they're going to monitor you closely, your whereabouts, make sure you get back to
I
court.
can go get my dog,
You're not permitted to have any contact with the victim.
even with an escort? Is that what you're saying, with a police escort?
You can't have
Am I-
contact with the victim under any circumstances. Is the victim at the location where your dog is?
I was renting a room, from my landlord, from a man, that I found on Craigslist, and yes, of
Okay.
course, I moved in with my dog.
All right,
But,
if you need to go get, ma'am, if you need to go get your, if you're with a police officer, you know, or a pretrial services monitor, and you need to go get your dog, as long as they're with you, that's fine. Just don't have any contact with the victim.
No, sir.
The victim, let's see.
It's 2 roommates.
Yeah, the victim,
Yes.
now there are 2. One is Stephanie Mononicholas,
Uh-huh.
and the other victim
Harold Drangsland.
is, right, Harold Drangsland. So no contact with those people, ma'am. That's, there are 2, yeah. There's 1 on the form, but there are 2 on the KPS. Yep. 2,000 total.
Thank you, Judge.
All right, good luck, ma'am.
Yes, sir.
All right, recall Sonia Cicero. All right, Ms. Cicero, I now have your probable cause affidavit. I'm going to take a moment to read it. Okay, counsel, you've had an opportunity to read this?
Yes, Judge, I've had an opportunity to review it. State would be asking for a $2,000 bond. The defendant does have another pending case for burglary of an occupied conveyance, as well as giving a false ID to law enforcement and petty theft.
Okay. All right, well, I find probable cause. There's no issue with that. No. Okay. All right. The bond is set at $2,000.
Skip over a couple of people, I'm not sure. North Broward just called me. Yes, he did. Okay. 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 That's why I keep on asking, who are we on? Yes.
All right, the next one I have is Joel Hossinth.
Yes, it's the three females that was here. Yeah, they kind of want.
North Rock, Your Honor, he's a medical reset.
Reset? Okay, thank you. Good morning, how are you? Good. Curtis Lightborn. He's bonded? Okay. All right, thank you.
Yes, he bonded.
Patricia Eugene. We're back on track?
She's President Maine, Your Honor. She advises me she's retained counsel. I believe the name was David Jaffe.
All right, so ma'am, you hired a lawyer,
Yes,
right? David Jaffe, is it?
yes,
Okay,
David Jaffe.
he's not here today. Do you want him to be present at your first hearing?
I would like that.
Okay, we can reset this to tomorrow, or we can reset it to Monday to give him an opportunity to be here.
No.
Your Honor, as a friend of the court, let me just explain to her real quick.
Okay, go ahead.
Right, she's going to sign up for a public defender today, Your Honor, and then she'll work it out with the private, and then if we have to withdraw, we will.
All right, that's what you want to do, ma'am? The public defender is going to represent you today, and then after today's hearing, you'll have your private attorney represent you if that's what you want to do, right?
Yes.
Okay. All right, so Ms. Eugene, you've been charged with several counts. Count one is obtaining property with value over $50,000 by fraud. Count two is a money laundering count, transferring $100,000 or more fraudulently. Count three, grand theft, first degree. Count four is using the identification of another to impersonate another person without consent. Count five, uttering a false or forged instrument. Number six, grand theft over $20,000 and less than $100,000. Count seven, again, another fraud using an ID of another. Count eight is uttering a false instrument. Count nine, grand theft between $20,000 and $100,000. Count 10, fraud, impersonating another person by using their ID. And count 11 is uttering a false instrument. And some of these have case numbers. There's an outstanding warrant reflected here with regard to counts 1 through 11. And that's here, a Broward County warrant, which sets certain bond conditions, $25,000 as to each counts 1 through 4, $5,000 as to count 5, $7,500 as to counts 6 and 7, $5,000 as to count 8, and $7,500 as to counts 9 and 10, and $5,000 as to count 11, for a total of $145,000. There are also special bond conditions imposed.
And Judge,
Yes, sir.
one of those special conditions is the Nebbia bond requirement.
The bond condition is that the defendant shall secure her release pursuant to a surety bond that is fully collateralized. The net value of the collateral must be in an amount equal to or in excess of the bond amount by real estate and/or tangible personal property. Obviously, property alleged to have been used in association or obtained in association with any crime couldn't be used. All right, anything else requested of the state?
No, Your Honor.
No, sir?
Your Honor, for Miss Eugene, she's lived in South Florida for 27 years. She owns a baking business. She makes in the range of $2,000 to $3,000 a month. So bonds are set. It's well out of her reach. I understand the total bond was $145,000. I also heard about the nebia requirement, and she's going to have to take that up, I believe, if she does retain private counsel or with a public defender division. But I would ask if on counts 1, 2, 3, and 4, just because those are the biggest ones, if the bonds could be lowered, if those could be $10,000 a count on counts 1, 2, 3, and 4, leaving bonds on counts 5 through 11 as is, and then it will be taken up, I presume, with the division judge.
And Judge, this was a warrant to arrest that was reviewed and the bond amounts were set. So I would ask that Your Honor not modify the conditions. They could have a hearing in front of the division judge. And in addition, just for the record, I'd like to indicate that special bond conditions include that she surrender her passport, not reapply for one, not possess any firearms, and she's to be monitored by pretrial services in the event that she does post bond.
Those are all conditions of bond or bail set out in the warrant. It is within this court's discretion with regard to a warrant to modify, but in light of the number of counts, the fact that respondents got personal counsel that she'd like to have used to address the court, I don't intend to exercise discretion to modify these amounts. We're going to leave them as they are. And ma'am, you'll have an opportunity to set a bond hearing before the division judge and address these, which is probably going to require some time and some detail. So I wish you good luck. You'll get a hearing before the division judge.
Do you happen to know who the division judge is, Your Honor? I just don't have it on my docket.
Maybe Madam Clerk.
Andrew Siegel.
Okay.
Judge
Thank
Siegel.
you.
Those are all remaining the condition of bond if bond is posted. Oh, I'm sorry. Jomi Roger.
Roger, Your Honor, she's approaching.
Thank you. Good morning, ma'am.
Good morning, sir.
How do you pronounce your name?
Naomi Roger.
Oh, it's Naomi. Okay.
Yes.
Looks like a J. All right. Ms. Roger, you've been charged with battery on an officer firefighter. Actually, 3 counts: resisting an officer or obstructing without violence, and escaping. And Ms. Roger, I've read the probable cause affidavit and find probable cause as to each count.
Judge, based on the allegations and the probable cause, state would be requesting $5,000 on count 1 and an increased bond amount on count 2 to $3,000. As to count 3, state would be requesting a $1,000 bond, and count 4, a $1,000 bond. On count 5, the bond amount 100 is sufficient.
Sure. Ma'am, can you raise your right hand to be sworn? Do you swear or affirm to tell the truth?
Yes, sir.
All right, thank you. The Assistant Public Defender is going to ask you a few questions. She's going to try to help you out.
Okay, thank
Okay.
you.
Ms. Rogers, do you have a job?
Yes, ma'am.
Where do you work?
All-American Facility Maintenance.
And how much are you making a month
Before tax, after taxes.
after taxes?
26, 2,600?
Okay, do you have any children?
No,
Do you provide for anyone financially?
no.
How long have you lived in South Florida?
Practically my whole life.
All your family's here?
No.
Where's your family?
Here in New York and California.
Why are you in a wheelchair? Do you have any medical issues?
Yeah, I broke my leg yesterday, so I don't understand how they said I attempted to flee. The officer hit my jaw. Mental health issues. I suffer from anxiety and depression.
Judge, I would ask for a lower bond. I've read through the probable cause. I do agree that there is probable cause, but it appears that she had lesser role to play than the other two people involved in the broken leg, medical attention, some of that, in order to put her on pretty good bond and release her.
And Judge, I will let you know that she does have another pending case, resisting officers with violence, battery on a licensed security officer, that she has pending in front of Judge Yuson.
She's out on bond in that case?
And Judge, I can check the amount of bond she's out on that case. Judge, on the misdemeanor battery, she's out on a $500 bond. She's out on a $1,000 bond on the battery on an officer. And it looks like she's out on a $500 bond with resisting with violence, which is a third-degree felony on that case. And she did pick up this case while out on bond. Your Honor, could sua sponte revoke her bond and hold her no bond on these new charges?
Well, that could be done. But in lieu of that, I'm going to set a bond in the following manner. With regard to count one, bond is set at $10,000. Count two, $2,500. Counts 3 and 4, $1,000 as to each, and then $100 as to count 5. All right, good luck to you, ma'am. Thank you.
Thank you.
Sierra St. Jean.
North Broward, they canceled her this morning.
She was canceled? Okay.
Yes, it's a felony case, yes, those don't come from it.
Oh, they don't come? Okay.
They go to their division.
All right.
Sorry, was that Sandra St.
Sierra Lane St. Jean.
Oh.
And apparently she's been canceled. Okay. Maria Puentes.
Ms. Fuentes is at the Paul Ryan facility now.
Good morning, Judge.
All right.
morning.
Good morning, ma'am. All right. Ms. Puentes, you've been charged with theft or larceny. Over $300, less than $10,000 from a person the age of 65 years or older. Count 2 is a fraud charge, uttering a false instrument. And count 3 is exploitation of the elderly, with the amount being less than $20,000. And I've reviewed the probable cause affidavit in this case, Ms. Puentes, and do find probable cause as to each of the offenses for which you have been charged.
Judge, considering the amount of charges, she's been charged with 31 counts.
I'm sorry, and I apologize. When I said count 2, what I should have said was counts 2 through 30 are fraud charges. So there were what amount to essentially 29 charges of fraud and uttering false instrument. And I apologize, ma'am, for not making that clear to you. Yes, ma'am, go ahead.
Judge, and she does have a pending case in front of Judge Yuson as well for fraudulent, fraud-related charges. I'm showing 15 charges that were presented. I'm not sure the status of the charges as of yet. Considering the fact she has pending charges, considering she's now being charged with 31 counts, state would be asking for an increase in bond on count 1 to $10,000. And the bond amounts can remain on counts 2 through 30. On count 31, state would be requesting a $5,000 bond.
Any dispute about the other case? All right, Ms. Puentes, I've got concern about the number of offenses, the fact that there apparently is a prior that's still pending. So I'm going to set bond for count 1 at $10,000. Counts 2 through 30 will remain at $1,000 each. And bond will be set at $1,000 for count 31, which is the exploitation charge.
Judge, what was that on count 31?
$1,000. So if my math is right, that's $40,000 total.
And Judge, state would be asking for no victim contact.
No victim contact. That will be a condition. So, ma'am, you can't have contact with the alleged victim, who is Henry Hamrick. All right, so no contact of any kind. Good luck to you. Thank you.
Thank you.
Next is Lubrion Pitts. I'm sorry, the first name is Ladarian Pitts. Nowhere? That was a trespass, maybe bonded out. All right.
Pitch is President Maine, Your Honor.
Oh, he's here, okay.
Yes, sir. He advised me, though, that his mother is either posting bond form or is in the process of it. So I just ask if Your Honor does find probable cause to leave the bond as set.
Okay, and I do find probable cause. We'll leave it set at the 25 that's already been set. Good luck, sir. Nicholas Chamberlain.
He's President, Your Honor. Both these are municipal ordinance counts, so I cannot represent him. He'll be representing himself.
Okay.
Good morning, Your Honor.
Good morning, sir. Mr. Chamberlain, you've been charged with violating a municipal ordinance on 2 occasions.
Yes, Your Honor.
And Judge, the state is not a party to this case either, but I can assist Your Honor if you'd like with priors.
Isn't there normally somebody here from the county? I'm having a little trouble hearing you with the noise. I apologize. Okay. All right. All right, sir. So I find probable cause with regard to with the charges. So.
Yes, sir. Yes, Your Honor.
What's that? They cut the sound off. I'm going to release him on his own recognizance. Sir, I'm going to release you on your own recognizance with the condition that you not go back to that location.
Yes, Your Honor.
All right? Don't go back there. That's, where is it?
Appears to be Fort Lauderdale Beach, Judge.
It's I guess it's a bench on the beach. I can't even tell you which one it is, so stay off the beach. All right, good luck.
Thank you, Your Honor.
Okay.
What's that?
Louis DePena.
President Maine, Your Honor.
All right, good morning, sir. Looks like you were picked up on an outstanding violation of probation warrant. Judge Brown signed a warrant, ordered that you be held no bond. So your next hearing will be before Judge Brown. You'll be held no bond till then. July 20th is your next hearing date, sir. Good luck. Vincent Sardo.
Good morning, sir.
All right, good morning, Mr. Sardo.
Good morning, Your Honor.
So you've got an outstanding capias. It's a capias on a petty theft, setting a $500 bond amount. It's in case number 17712 MM30A. So you'll have to post a $500 bond, sir, to be released.
Do I gotta post the whole 500?
Pardon me?
Would I have to post the whole 500?
Well, it depends if it's going to be a cash bond or not. But that's the bond amount, $500. Okay, good luck.
Thank you.
Stephen Maliani.
North Road, Your Honor.
Thank you. Okay, good morning, sir.
Good morning, sir.
Mr. Maliani, is that it?
Yes, sir.
Okay. You've been charged with 3 counts of violating a municipal ordinance. So, sir, I'm going to release you on your own recognizance, and you need to show up at your court hearing.
Okay, thank you, sir.
I do find probable cause. Michael Ehrman.
President May, Your Honor.
Okay, good morning, sir.
Good morning, Your Honor.
So, Mr. Ehrman, it looks like you were picked up on a outstanding violation of probation warrant. This is a warrant from May 1990. Judge Kathleen Carney, county court judge at the time. And the bond amount was set at $2,500. I don't know who the current judge is, but that was
Judge, I can look it up.
before my time.
That would be Judge Pohl.
Okay.
It is correct. It's showing Judge Pohl. Your Honor has the discretion.
July 28th. So, Mr. Ehrman, you're going to have a status hearing. Say it one more time. Next hearing will be before Judge Pohl on July 19th.
Your Honor, for
Yes, sir.
Mr. Ehrman, he advises me, he's unable to post the $2,500 bond that was put on this. This was almost 30 years ago. He tells me he now has a valid Florida driver's license. He's already been in custody for 6 days. He tells me he got picked up at Glades County, and so he got to Broward this morning or last night, and so he's already been in custody for 6 days. He cares for his grandmother who has Alzheimer's. Someone else is caring for her right now, but that's not going to be a long-term solution. He's lived in Florida nearly his entire life. He believes it's actually because of a missed court date. He doesn't believe he was actually on probation. He thinks it was a capias for a missed court date. Either way, he's unable to post the bond I said. I would ask if you could ROR him, given the fact that this is almost something that's 30 years old. And the only reason he got picked up, it was for a traffic infraction. He stayed out of trouble. He hasn't had contact with police since this warrant, which was filed almost 30 years ago.
Okay, state.
And Judge, the only concern I have is the fact that he has failed to present himself in front of the court, which is why the warrant was pending and served upon him. So in order to secure his appearance in front of the judge, I would ask that you just remand him, keep him remanded until that court date where he can address it in front of the court, since he's failed to appear for 30 years.
Okay. So, Mr. Ehrman, both are legitimate concerns. I mean, it's been a long time. You haven't had trouble, apparently. You haven't been picked up. On the other hand, it's been a long time since you came before the court when you were supposed to be here. So I'm gonna modify the bond. I'm gonna modify the bond to $1,000. Give you a chance to post that bond so you can get out.
Your Honor, would you consider maybe putting him on pretrial and a GPS monitor? He's telling me he has no money to post bond, that any monetary amount he's going to be held. So even if Your Honor could consider putting him on pretrial with the GPS monitor, the court will know where he is. He just cannot post a monetary bond, and he's worried about caring for his grandmother that he's already been in custody for the 6 days.
Okay, sir, you don't work?
Actually, I'm fired because of this situation. I worked construction, and I've been out of work now for 6 days, and all the money I have goes towards taking care of my grandmother and her medication, so.
All right, does he qualify for pretrial services? He wouldn't because of the condition, yeah. Yeah, pretrial services won't take him because, I assume because he didn't show up for court in the warrant. So, I'm gonna leave the bond at $1,000, sir. You're gonna have to try to make some arrangements. All right, good luck to you, sir. Cameron Pope.
Mr. President, approaching, Your Honor.
All right, Mr. Pope, there's an outstanding capias, a no bond capias. And that's on case number 15-9715, MM10A. And what is the date, July? All right, then the status hearing will be July 20th, sir, so you'll see the judge then. Willie Murphy.
Present, Your Honor.
All right, good morning, sir. Good morning, ma'am.
Good morning.
Hi, what is your name?
My name is Tashia Brunson.
Brinson or Brunson?
Brunson. B-R-U-N.
Got it.
I'm his sister.
Okay, all right. So, Mr. Murphy has been charged with battery, misdemeanor battery, on the victim's last name is Perdelis. So you're not the victim in the case, obviously. Okay. And I've reviewed the probable cause affidavit and do find probable cause.
Judge, the state would just be asking for no victim contact in this case, in addition to the bond of $1,000 that's already set.
Ms. Brunson, the defendant's sister is having a chat with the attorney in court here. Yes, ma'am. Okay. Okay, sir, while they're chatting, is there something you wanted to tell me?
Your Honor, for Mr. Murphy, he lives with the sister. I believe that's the sister he actually lives with. He attends Coconut Creek High School. He's going to be a senior this upcoming year. He's currently, he's going to be turning 19 in September. Because he's a high school student, he doesn't have any money in the bank. He doesn't have a job. He tells me this is the first arrest this is his first time he's come into court, and the first arrest that he's ever had. I would ask if you would consider RORing him or putting him on pretrial. I believe the sister could verify his address if needed, since he does live with her.
Judge, they would have no objection for ROR to standard pretrial with no victim conduct.
All right, and he qualifies for pretrial?
This type of charge, Your Honor, we don't recommend, but I refer to Your Honor, if you want to supervise him.
Unless it's, Your Honor, can I ask, has the sister already posted the bond? Because I know sometimes family members might post the bond, but then it doesn't hit the system for 8 hours. Has she posted it?
I'm being advised that
Okay.
that's not occurred, yeah.
That's fine.
Yeah. And I'm sorry, I know he interrupted you.
We don't typically put people on pretrial because of this type of charge. It's a violent charge, but we refer to Your Honor. We will supervise it if you put him on.
Okay. All right, well, given the defendant's age, I've read the petition yet again. I mean, it does allege a significant violent event, but under the circumstances, to get Ms. Murphy out, I'll put him on pretrial release, and ma'am, he's gonna live with you, right?
Yes.
Ms. Brunson? All right, and you're gonna assist to make sure he shows up for court?
Yes, sir.
All right, Mr. Murphy, you can't have any contact with the alleged victim in the case, who is Ashley Perdelis. No standard pretrial release, no contact with the victim.
Is it 1,000 and standard pretrial?
No, OR with pretrial release.
Thank you, Your Honor. Apologize.
No, my fault. Benjamin Caesar.
Present, Your Honor.
All right, Mr. Caesar been charged with possession of cannabis 20 grams or less, and possession of synthetic cannabis 3 grams or less. Yeah, I don't find that there's PC.
And Judge, I don't object. I don't see any indication that the drug was field tested. I'd ask for 48 hours to perfect.
Okay, no objection by the, so, sir, I don't find there's probable cause based on the affidavit, because there's no indication that they tested whatever it was, but the state should have an opportunity to perfect that if they can, so there'll be 48 hours given to do that.
Your Honor, if I may, Mr. Caesar tells me he can't post a $100 bond. I understand the state's asking for the 48 hours, but because he can't post $100, it's going to basically be a no-hold bond for him for 48 hours until he's back in front of a judge. I would ask, Your Honor, if you consider, because even if no PC is found a magistrate, that's not going to end the case. And so that I would ask if maybe Your Honor could consider maybe lowering the bond in the meantime. If you could lower it to maybe $40, he has some money in custody here that he could at least bond out in the meantime while the state reviews it. And the case will remain open even if Your Honor finds no probable cause. I just don't want him to be held for 2 days on a cannabis case on $100 if he can't afford it. So I'd ask Your Honor if you could make it $40 just so he can bond out in the interim.
Okay, state.
Judge, I defer to Your Honor. It's a cannabis charge.
All right, that's fine. We'll lower it to $40. All right, sir, good luck. William Hennigan. I think that's the lowest bond I've ever, $40, yeah.
Present, Your Honor.
Good morning, Your Honor.
Good morning, sir. Sir, you've been charged with resisting an officer without violence. And I do find probable cause, having read the probable cause affidavit. And the standard bond is $100. You can post that, sir?
No, he cannot post it, Your Honor. Mr. Hennigan, he's currently homeless. He does have an address through BOC, though. So if he is either ROR'd or he's put on pretrial, he does have an address that he can give so he can get the court notices. But because he's homeless, he can't afford the $100 bond.
State.
Judge, I would have an objection to ROR. The defendant has 7 pending municipal ordinance violations, all, no lodging on the beach, sleeping on a public property, trespass, aggressive panhandling, carrying an open container, as well as very similar priors stemming all the way back to 1986. Based on his significant priors, I would object to an ROR. The bond is set at $100. It's very minimal.
Yes, sir.
Your Honor, also, if you won't consider lowering the bond, Mr. Hennigan advises that if Your Honor, or would ask if Your Honor would consider resolving the misdemeanor case today and then RORing him on the municipal ordinances as there is no city attorney present.
Not without the officer being here. Mr. Hennigan, I'm going to leave the bond at $100. I think that's reasonable under the circumstances. Good luck to you, sir. Thank you. Anthony Brown. Anthony Brown.
He bonded, Your Honor.
Okay, thank you. John Clayton.
Present, Your Honor.
Good morning, Mr. Clayton. You've been charged with possession of cannabis 20 grams or less. And in this case, I do find probable cause. So that the bond is at $100. Okay.
That's fine, Your Honor. No objection.
All right, thank you. Good luck, sir. Craig Smith. Thank you. Mr. Smith bonded.
He bonded, Your Honor.
Okay. Jaron Peterson. You said medical?
Yes, sir.
Okay, thank you. Noah Seethammer.
He's at the copy.
Thank you. Good morning, sir.
Good morning.
How do you pronounce your last name, sir?
It's Sighthammer.
Sighthammer, I apologize. Sir, there's an outstanding warrant. I guess that's why you're in. A warrant issued by Judge Carpenter Toy, July 12th, in case number 173903, 10 MM10A. And Judge Carpenter set a $5,000 bond on the warrant. You got a July 20th hearing date. If you can post bond, you can get out before then. If not, you'll see the judge then. All right,
Okay,
good luck
thank
to you,
you.
sir. Thank you. Is there a second count on that? Let's see.
Judge, I only show one count.
Well, I'm confused. The warrant says $5,000, but the form I'm looking at, the probable cause determination says 1,000. Were there two counts or
Oh,
two different warrants?
Maybe there was another count, but he's only violated on count 2.
Oh, I see, okay. I'm looking at the warrant. It says 5,000 is count 1. I don't see a notice to the bond on count 2. But it's just, it appears to be a one-count warrant.
Maybe in count one was no cost, Judge, that usually sometimes happens.
Okay. So, sir, did you appear before the court a couple days ago?
Yeah, I did.
And did you go before Judge Carpenter Toy?
No, I went for a furlough hearing, for a furlough motion.
Oh, maybe it's,
Yeah, if that's already been addressed, I don't really see what would. All right, so it looks like your case has already been addressed, right, sir?
Yeah.
Okay, I'm not sure why you're listed here, and I'm not sure what this is, but there's nothing but the warrant, which apparently you've already addressed with Judge Carpenter Toy, so there's nothing to do today.
Judge, I do see there's a hearing for in-custody violation of probation set on July 20th in front of Judge Carpenter Toy, but
Okay.
I guess for now, we can just delete this.
All right, so we'll just delete this, and you'll see Judge Carpenter Toy on the next hearing date.
All right, thank you.
All right. What's that? Yeah, we're not done. All right, we're going to take a recess so we can review these. Ladies, have you received a copy of these other PCs? The additional, I haven't looked at them yet, so we're gonna take a break so I can start reviewing these, and I'll get through maybe most of them, and then we'll get started again.
Thanks, Judge.
All right, we'll go off the record.